Good day, Crime Talk aficionados. It's Saturday, and that means one thing: the highlights throughout the week from Crime Talk. Hope you enjoy it. Have a wonderful weekend, and we'll see you next week with all new content here on Crime Talk. All right, let's get to the docket today. First, Leticia Stout. What is this woman doing? As most people know, if you're a follower here at Crime Talk, you know that Leticia Stout fired her public defenders so that she can represent her case in the allegations of murder against her 11-year-old stepson, Gillane Stout. No one should represent themselves in court. It really just is not a good thing to do. It has been said that he who represents himself has a fool for a client. I totally agree with that. One of the reasons that you hire an attorney is for their training and experience, but also for the fact that they're supposed to remove themselves from the emotion of the battle and give you sound legal advice. So Leticia Stout decided that she was going to represent herself. And of course, what does every pro se defendant need to do if they're going to represent themselves? By God, they're going to do their first case, a first-degree murder case. They should probably go to the law library. And they need to gain all the knowledge that they possibly can in roughly a year time period that took most people in law school. Obviously, 3 years is the normal course. And then you have years of experience practicing, understanding what are the rules of evidence, tactical things that you learn in other cases over the years so that you can be a zealous advocate for your client. But Leticia Stout, she knows better. She doesn't need anything. Well, she was signed up to go to the law library at the El Paso County Criminal Justice Center. And that's obviously in Colorado Springs. It's not really close to the courthouse. You got to zig and zag. It's almost like a kind of a quasi-industrial park. It's been years since I've been down there. But like most jails, they have a law library, which usually consists of some books, maybe access to Westlaw, something along those lines, LexisNexis, so that people can look up case law when they really should be reading the rules of evidence and the rules of criminal procedure. But anyway, the sheriff had noticed that Leticia Stout had signed up to go to the law library in their law library program, but she doesn't want to go. So, as I've said it before, if it's not on paper, it didn't happen. And this particular way, Leticia Stout cannot claim later that she did not have an opportunity to prepare for her case because she was denied access to the law library. The sheriff's department obviously has dealt with this before. They are covering their bases, and frankly, my hat is off to them. So the sheriff's department usually doesn't get involved in cases at all unless until the court inquires. But in this particular case, the El Paso County Sheriff's Office, through their attorney at the county attorney's office, went out of their way to tell the court that Ms. Stout had completed and signed up for their law library request form and was provided a copy of the library rules. The law library rules indicate that the inmates don't select the time that they go to the law library. They get told what time they can go to the library because why? It's jail, right? You don't get to do what you want to do. It's no longer like going to Burger King and saying, I'm going to have it my way. It doesn't work that way anymore. So on March 30th, Ms. Stout refused to go to the law library. And then Ms. Stout was reminded by the jail personnel that if you refuse to go to the law library, that you will be removed from that list for some 90 days. Well, Ms. Stout refused to go to the law library. Even better yet, the sheriff's office, at the advice of their attorney, had the officer who was involved in this exchange with Leticia Stout do an affidavit. And it doesn't read well for Leticia Stout. In this particular case, a Commander Cy Gillespie was talking to Miss Stout and said, hey, you need to take advantage of the law library. Otherwise, your refusal can prevent you from actually going to the law library. And Miss Stout repeatedly said to Mr. Cy Gillespie, take me off the library list, and that she didn't need the law library. I told her the refusal would result in suspension from her law library privileges for 90 days. And then it goes on to state that Ms. Stout stated her reason for refusing to attend during the hours we'd specify for her was because of medical concerns. She was concerned that her drowsiness would interfere with the early morning hours of her law library slots. Now, she was instructed that the medical staff could address her medical concerns to better fit with her assigned law library schedule, but inmate Stout began to argue about her specific circumstances and asked if I would be expected her to sleep all day. Mr. Gillespie once again said it's in her best interest to participate in the law library program as a pro se inmate, and that they, being the sheriff's office, could address her medical concerns to work with her law library times. She said, she being Leticia Stout, said, take me off the list. Okay, this is not going to help Leticia Stout. Why? Because it's simply going to show that she is not utilizing her time to prepare. What's the good thing about that? There will be no delays. And the court now has a record as to why no delays will be had, because she is the one refusing to cooperate, to accommodate the schedule that's been set, even though the sheriff said, we'll try to work around your medical concerns. Now, it doesn't go into medical concerns in this particular case because that would be a violation of all the HIPAA laws and things of that nature, but it gives you an idea where we're coming from. I'm not sure Miss Stout truly appreciates the gravity of the situation that she is in right now. She is looking at facing the rest of her life in prison. I'm not sure Miss Stout appreciates the seriousness of the situation that she finds herself in. She is charged with an offense that can carry her being sent to prison for the rest of her life, i.e. die in prison. She's already done some very poor things by firing competent counsel. She's apparently made no arrangements through her family to hire private counsel, and she is simply spiraling out of control here. Now, maybe she has mental health issues, but we have to remember she's received 2 competency evaluations, and both doctors, one who was really hired by the defense, said she's competent. So at least we know this case will be making some progress soon, and she can't claim ineffective assistance of counsel when you represent yourself. We'll have to see if the trial will turn into as big a circus as the early pretrial proceedings. We'll wait and see. Now, next on the docket, if this case doesn't scare the hell out of you, I do not know what will. And I'm not trying to scare you, but ladies and gentlemen, we have said this before. The world is a dangerous place. Take it from me, your local neighborhood criminal defense attorney. There are some bad people out there. Now, we got to give them due process. I get that. But take a listen to this. An Indiana man is now facing attempted murder charges after authorities found a badly beaten 9-year-old inside of his home. Now, who did this 9-year-old happen to be? His neighbor. Now, the child was reported missing by the parents shortly after 7 p.m. While questioning neighbors doing a neighborhood sweep, several of them told officers that the child's next-door neighbor, James Brian Chadwell II, said he saw the girl after she disappeared. When the officers arrived at Chadwell's house, he denied knowing the victim's whereabouts, but said that she had been by the home earlier but had left. Now, Chadwell gave permission to the police officers to search the home. They came to a door that had a chain lock on it. They could hear a child crying. Exigent circumstances at that point, they go in and recover the girl. Now, fortunately, she is alive, but Mr. Chadwell has been charged with child molestation, attempted child molestation, battery resulting in serious bodily injury, criminal confinement, and strangulation. Prosecutors filed a sentencing enhancer charge of the suspect because he is a habitual offender, and that could add an additional 20 years to Chadwell's sentence. Needless to say, the prosecutor doesn't want Mr. Chadwell, the bad guy who will give the presumption of innocence, to ever get out of prison again. Now, ladies and gentlemen, what does somebody look like who's going to kidnap the 9-year-old girl next door? I don't know. Well, this guy does. But if you're not sure about your neighbors or you have any doubt who's in your neighborhood, I'm telling you, take a look at this commercial when we take this quick break. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Did a juror speaking publicly about the juror deliberations in the Derek Chauvin matter create an issue on appeal, perhaps for a new trial? That's right. Someone may have just done that. So Brandon Mitchell, he gave an interview on live television the other day, and he was formerly known as juror number 52 in the case of former police officer Derek Chauvin. Now, Mitchell is a 31-year-old basketball coach at North Community High School in Minneapolis, where he said that the 11 jurors there didn't watch the news during the trial or deliberations, so they were not aware of any of the racial climate or protests going on outside. Well, that's certainly good for the prosecution. However, what Mr. Mitchell said a little later in the interview is probably giving the district attorney, or the attorney general in this particular case, a little pause, but giving Mr. Nelson, attorney for Mr. Chauvin, a little bit of hope that they may have a new trial. When asked about how the jury deliberations went, he said the deliberations were relatively straightforward. There were a few hiccups with terminology and understanding exactly what the instructions were. He said there wasn't a whole lot of banter back and forth, but he did say that one juror that was kind of, he wouldn't say slowing us down, but was being delicate with the process more so, was just kind of hung up on a few words within the instructions and just wanted to make sure they got everything right. Well, that's what jurors are supposed to do. They are supposed to get hung up on the words. Those words have specific meaning. Now, Mr. Mitchell went on and publicly extended his condolences to the Floyd family and let them know that his name is going to live on. That's very nice. What Mr. Mitchell did in making his public comments has created an issue. It wasn't giving his condolences to the family. It wasn't saying, hey, a couple of the jurors, or at least one juror, wanted to really read the instructions where we've kind of glossing over everything. No, what he said was, it was probably to the detriment that he, referring to Mr. Chauvin, didn't take the stand because people were curious on what his thoughts were throughout the entire incident. Well, we've talked about this many times, ladies and gentlemen. The defendant never has to testify. And in fact, the judge, in this case, as well as many, many others, in fact, all of them, states that the defendant is never compelled to testify and that you cannot use their silence, i.e. not testifying, against them in any way. In fact, you cannot consider it in any way. But Mr. Mitchell's statement basically clearly states they considered it. Now, had he not gone on TV, this may never have been an issue. And now it is going to be. I'm sure Mr. Mitchell meant well, but he just opened up a can of worms, and I'm sure the Attorney General in Minnesota right now is probably doing a little bit of research or having someone on the staff do a little bit of research to see if these public comments give rise to a motion for a new trial. Next on the docket, is there a break in the Delphi murders? Yesterday, we brought you a story about, well, a guy that's just, we'll give him the presumption of innocence, but let's face it, a little creepy. And if he is convicted or pleads guilty to what he is accused of, he probably deserves to spend the rest of his life in prison. The man that I'm talking to you about is a man by the name of James Brian Chadwell II. Well, he had a young girl who was the next door neighbor in his basement. The police were called when the parents noticed that she had been missing, and when they were doing a neighborhood canvass of the area, one of the neighbors indicated that Mr. Chadwell stated that he had seen the child after her disappearance. When the police arrive at the house, he says, well, I really don't know, but she was here, but she left. Hey, can we search the house? They search the house, and guess what? They find a 9-year-old girl in the basement in a locked room. Mr. Chadwell was obviously arrested and faces some very serious charges. Well, let's recap the Delphi murders. This goes back to February 14th of 2017. Approximately 20 miles from Lafayette, Indiana, where Mr. Chadwell resides, in Delphi, 2 girls were found murdered near the Monon High Bridge. Libby German, 14, and Abby Williams, 13, and they had taken a hike on the abandoned bridge the previous day. The outing was only meant to last a few hours. The girls took photos while strolling across the bridge, but as time passed and their family didn't hear from them, they became worried and called authorities for assistance. Police found the girls' lifeless bodies a short distance from the bridge. Now, after their deaths, the incident was nicknamed the Snapchat Murders, after Abby took a photo of Libby at around 2:17 p.m. and put it on social media. Detective says that after the photo was taken, a man approached the girls and apparently told them to go down the hill. One of the girls, likely sensing danger, recorded the man's voice on her cell phone. She also managed to take a photo and record a small clip of the suspect. Although his face isn't clear in the picture, it was enough to give authorities a general description. Since then, they've poured through thousands of tips related to this case. And anyone who has information should still contact the Delphi Homicide Investigation tip line at 844-459-5786. The police now are investigating Mr. Chadwell because if you would take a look at the descriptions and the artistic drawings that the police have come up with over the years, one could reasonably conclude that the gentleman in the artist's rendering and the artist's drawing bears some resemblance to Mr. Chadwell. Wouldn't that be great for the family if there was, in fact, actually a break? Now, Mr. Chadwell has been charged with child molestation, attempted child molestation, battery resulting in serious bodily injury, criminal confinement, as well as strangulation. He is being looked at possible sentencing enhancers as a possible habitual offender, and he could add up to at least 20 years in prison, which seems like a very short amount of time, given the fact that there's allegations of child molestation. We'll keep you updated. Next on the docket, Gillane Maxwell. The struggle continues. Now, Miss Maxwell is 59 years old, and have to say that the first photo that was released of Miss Maxwell, a picture taken by her attorneys to document what they believe to be a black eye, a bruise of some type that Miss Maxwell would not tell her attorneys how she received it. There have been allegations that she is being abused by the correctional officers there at the Federal Detention Center in New York, but apparently Miss Maxwell is keeping mum. Now, Certainly not going to want to be accused of anything, but I'm sure this is not the photo that Miss Maxwell, who used to live a glamorous lifestyle, would want being sent out to the public. She looks like she has aged a little bit. She kind of looks like the witch in the play Wicked. But I'm not disparaging her. I'm just kind of saying this is kind of what she looks like. She's got some problems there. Certainly, we don't want anyone to be abused while they're in custody, right? Because we're the good guys. We're better than that. And here in the United States, we treat everyone with dignity and respect. Miss Maxwell may get some relief in her detention in response to a motion filed by her attorneys stating that Miss Maxwell's sleep is being disrupted, which is harming her health and compromising her ability to assist in the preparation of her defense. The judge has ordered that the prosecutors find out if the correctional officers at the federal detention facility are in fact waking Miss Maxwell up every 15 minutes throughout the evening and night so that they can see if she is still alive. If that in fact is the case, the judge wants to know the justification for that reason. Now, on a side note here, we all know, according to the Gillane Maxwell Suicided Watch, Miss Maxwell has been in custody since July 2nd of last year. Her trial date is set for July of this year, 2021. I would submit to you that Miss Maxwell's case is not only much more severe than the Lori Vallow Chad Daybell matters, it is much more complicated than the Lori Vallow Chad Daybell matter, and yet they are going to have a trial literally within 1 year in a complex case. Don't you find that interesting? I certainly do. Just saying, Idaho, maybe we could get the ball rolling.